So, Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's, or vague, that it's unconstitutionally vague. We found case law saying.
Quick legal checkpoint. When a defense claims a statute is unconstitutionally vague, they're arguing the law is too unclear for an average person to know what's illegal. But then the prosecution fires back with case law that undercuts that claim. It's always fascinating to watch legal chess play out in real time.
Unconstitutionally vague. It's from DeContal versus State. I've tendered it to defense. Can I approach Judge?
I gotta imagine that if it was unconstitutionally vague, someone would have challenged it, and it would have,
Well, maybe I haven't had my case yet.
Okay.
And I'm happy for you to make new law. Always.
Judge, I hand you DeContal versus State. I just
DeCantel.
Yes.
Yeah. Oh, look, it's out of Court 8 in Harris County. So why are you saying that there's no PC in this case?
Is there a PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. So they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
he doesn't
being arrested doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his, I guess he uses
He's in
his
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watched the video.
We watched the video and we have a timestamp, Judge.
Could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable to do it by themselves, or is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And that's why they had to push him back into.
Whoa, hold up. Did you hear that? The officer charges him with resisting transport, but can't clearly explain why. That's like handing out punishment before identifying the rule that was broken. So tell me, does that sound like due process to you? Drop your thoughts in the comments.
He leans forward. He's yelling at his mom. Record, call. The third time they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cop's sitting there going, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking of it. DA, Officer Singh, it's a 27-minute video. Okay? At no point is the DA's office called to this point. Okay? That happens after. Fine. For an assault, they can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine. They are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's common for officers to conduct an investigation before they call intake. That's not an abnormal thing.
I mean, that's neither here nor there. But the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Zenon, Your Honor.
Mr. Zenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge,
and I ask at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
we can watch the video, Judge.
Cue it up. Let's watch.
I'm just turning the volume up, Judge, as well.
He talking about don't let him pull up. They talking about I got a warrant out for Fort Bend County for Assault. Look, he pushing me. Mama, record me. Mama, look. Mama, look. Record him. Now you're under arrest. I'm under arrest. You got a new charge, Bubba. Resistant transport. Resistant? I wouldn't resist it. You just resisted transport. Yeah.
What the hell is that?
Now you got a new charge. Yeah.
Come on.
Thank you,
These
Judge.
officers are working intake. They're-
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating a legitimate.
I know, but no. All right, I'm with
Do you
you.
see why I'm so upset, Your Honor?
All right.
Okay. Thank you.
Could even refile this as resisting.
Yeah, look, yeah, I mean, you're not gonna hurt our feelings. You need to do what you need to do. Perhaps it was the wrong one, but yeah. Was it resisting?
Nope.
My name is Bennett and I ain't in it. But no PC.
Thank you, Your Honor.
Jail and/or a $4,000 fine.
On April 20th, 2025, in Harrison County, Texas, a law enforcement officer was dispatched to a disturbance of a weapon call at a hotel. The hotel staff said that an unidentified third party alerted them that the defendant had a weapon. The defendant was detained, and a witness told the law enforcement officers the defendant had a backpack behind a bush prior to the law enforcement officers' arrival. The backpack was recovered, and a handgun was found in the backpack. The defendant is currently 19 years old.
You like Skip. How do they know the backpack was his? What was he doing wrong?
There was a witness, Your Honor, that stated that they saw the defendant hide the backpack behind a bush. And the hotel staff was able to identify the defendant as the individual that they were told had a gun. And that's when the officer.
Was he just standing while black or something? What's he doing wrong?
They were just alerted.
No. I'm gonna find no probable cause in your case, Mr. Narcisse. Be careful, man. So many out there out to get you, put you down. Hang tight for me.
We're approaching on Mr. Jeremiah Cummings. That's the one about the deadly conduct.
I don't remember. I mean, I don't remember what happened for breakfast, so you're gonna have to refresh my memory. What happened?
Yes, sir. I'll just read the summary. On April 11th, 2025, in Harrison County, Texas, an officer was dispatched to a family disturbance call and met with the complaining witness. The complaining witness said that an argument occurred between her and the defendant, and that the defendant grabbed his handgun and held it in his hand as his anger intensified. The complaining witness left the apartment due to fear, returned to the apartment and contacted the sheriff's office to report the incident. When the officer approached the defendant, he stated, "I'm not talking, I'm answering questions." Gathered his things and grabbed a handgun and placed it in his pants. The officer then drew a weapon and said, shoot me, then. The deadly conduct, Your Honor, is alleged based on the fact that the defendant was holding the gun during the argument with the complaining witness.
Does that mean that if anyone ever gets into an argument and has a gun in their hand, that they're literally, I mean, theoretically guilty of a deadly conduct just by virtue of, and then what kind of argument can it be? What level of discourse must there be for someone to be,
Right, and
That can't be the law.
Talking about this one where it's not a terroristic threat or an hang-off, and nothing was really said, it was like pointed at her. We have also spoken.
So, I mean, think about this. Like, let's say you and I are arguing, right? And I'm mad at you and I just, I get the gun just to put it somewhere else,
Right. I get it. And I mean, wasn't charged as an ag.
I get it, but
We have spoken to the complainant. I think I remember last time with this case, you wanted to hear from the complainant, just before you made a PC.
do you have anything else?
She said he had a gun,
Is he here?
No,
He's not
he
here.
waived his appearance.
Right. I remember. Yeah. All right. I'm going to find no problem.
All right. Did you want to also then speak to Mrs.
Come up, ma'am. You tested positive for meth. I can't let you go. That's just it's too much. I have to revoke your bond, ma'am.
I don't do nothing. I'm prescribed.
I just tested you. You tested positive for meth.
Yes, sir, but the medication that I'm taking, that's why I've been trying to get it.
Adderall doesn't test positive for meth. Show me a study. Show me something that says Adderall tests positive for meth. But no.
All right, time for some legal myth busting. Adderall doesn't magically show up as meth on a drug test. But here's the catch. Courts expect full disclosure of valid prescriptions, especially under pretrial supervision. This is where medicine, the law, and personal responsibility collide right in the courtroom.
I don't believe that's a good, I mean, I'm in pre-trial, it's just. Have you heard of Adderall testing positive for meth?
I have not heard.
No. You're supposed to give, when you're being supervised by pretrial, you are supposed to give them any and all prescriptions that you're taking so that they can cross-reference any positives with any kind of drugs that you're taking. Adderall doesn't test positive for meth.
That's not the only thing that I'm taking, sir.
So when she was in court the first time, she really was in a blank state.
I get it. I'm not talking.
And so at that time, when I asked about all the different prescriptions, she was very like scatterbrained. She was able to provide me with the prescriptions that they gave her when she went to the hospital for the assault.
So let's do this. Let's do this. Let's do this. I will give, you can give that to them so they can check it out to see if there's something that would possibly test positive for meth. But I just don't think there is. You're not, I've ordered you not to use alcohol, illegal drugs, you're not to use. There may be things that happen in our lives. You're supposed to find a good way to be able to deal with, PTSD. We all have it. We all do. But you have to find a positive way to deal with things. And illegal drugs is not it, especially when you're on bond for a very serious crime. So take a seat from the jury box. I will have them check it out to see what, if anything, would.
She's already provided prescriptions that she has when she went to test.
I don't know, maybe she has something different. And have you looked at all those prescriptions?
I mean, the whole list and disclosed the prescription.
Okay, ma'am, take a seat for me in the jury box.